23rd, and our records through April 3rd, we have on vacation.
And we said the 23rd, that's the 23rd of March.
Correct.
Excuse me. Did you have any questions you wanted to ask her?
Sure. So you said you spoke to Jennifer Mimsal, right?
I contacted her
Okay, how'd you contact her?
via text message.
Okay. And then who did she contact?
I do not.
You don't know who Dr. Garcia Joven's supervisor is?
I know who his supervisor is, but I don't know for sure if Jennifer Maddaleni.
So you don't know where this information came from, is that what you're saying?
I got it from Jennifer Maddaleni.
Sure, and but you don't know where she got it from.
I did not.
Okay, and so to be clear on the information that you have is that Dr. Garcia Joven Garcia Joven's on vacation or what?
Correct.
Okay, and so when somebody's on vacation, do they have to report to you if they're ill?
No.
No, okay. So Dr. Garcia Joven would not have had to report to you today that he was ill, correct?
Correct.
Okay. And when an employee's on vacation, they inform you where their location is?
They do not have to.
Okay. Do you know where Dr. Garcia Joven is?
I personally do not know.
Okay. Do you know anybody who does? Okay. Do you know how Mr. Reardon got the impression that Dr. Garcia Joven was in Columbia?
Do you know how many
Well,
What do you mean, well?
it's the conversations that we had. Do I need to?
That's a true point.
That's absolutely not attorney-client privilege.
So you, well, I guess, so you do not know that, well, let me think this right, I see I have a tickle in my throat. So I'm understanding you correctly. You found out that it's your belief that Dr. Garcia Joven is in Columbia based on your communication with Attorney Reardon?
No. Through my communication with Jennifer Maddaleni.
How did Jennifer Mimsal determine that Dr. Garcia Joven is in Columbia?
I don't know who she spoke to. She responded back that he needed to vacation, the scheduled vacation March 23rd through April.
But she didn't say anything about where he was going to be at.
She said Columbia.
Okay. You can continue with your questioning.
Okay. So who did you tell what Jennifer Mimsal told you?
Again, I think we're getting to a true client privilege.
Did you talk to Attorney Reardon about that then?
Yes.
Did you talk to anybody else about that?
And Attorney Maloney was on the phone as well.
Did you talk to anybody outside Attorney Maloney or Attorney Reardon?
No.
When did this conversation take place?
This morning,
Okay, at what time?
I want to say, I can't tell for sure.
Okay.
Between 7 or 8, something along those lines. I can't remember.
And when did you text Jennifer Mimsal?
Probably around 7 before that.
Okay, but this morning, right?
Correct.
Did anybody contact you last night?
No.
No, okay. Did you go to law school?
Yes.
Where'd you go to law school?
University of Wisconsin.
Are you currently a practicing attorney?
No, I'm not practicing.
Okay, but you have a law degree, correct?
Correct.
Okay. And you know what hearsay is, right?
Again, Judge, I think that our field is issue involved is continuation.
Cross-examination is open in the state, Judge.
This is not cross-examination. we're trying to establish that your client is out of the country, which you indicated he is. He's in Colombia, you indicated. You indicated he's out beginning of the 23rd. The only thing we need to establish is whether he was going to return for this hearing, which we don't believe he was, because his vacation was scheduled through April 3rd, 2023.
And I guess before I guess you can answer the question, do you know what hearsay evidence is?
Yes.
Okay. And did you discuss Dr. Garcia Joven's travel plans with him at any time?
No,
Do you know if Jennifer Mintz Howell discussed Dr. Garcia Joven's travel plans with him at any time?
I don't.
No. And you don't know who Dr. Jennifer Mintz Howell allegedly discussed Dr. Garcia Joven's travel plans with, correct? No. Okay. So, and you don't know whether Dr. Garcia Joven was planning on appearing here today or not, do you?
No, I do not know.
No. Okay. And did you tell that to Mr. Reardon at any time?
I'm not going to talk about what I was going to tell.
Right, yeah, we don't need to get into their conversation.
Okay. When did you know that you hadn't talked to, you didn't know whether or not Dr. Garcia Joven was returning from Colombia?
Can you repeat the question?
At what time did you know that information, that Dr. Garcia, that you do not know whether or not Dr. Garcia Joven is returning from Colombia to be here today?
When did I not know?
No, when did you know that you didn't know that?
That's a confusing question.
I'm okay with that.
I
You don't know?
understand. I don't understand.
Okay.
I'm sorry, I'm just going to object here, obviously, this is a very confusing question. But I think what we can do here to shortcut this is have attorney Cross get the flight information from Dr. Garcia Joven to confirm when he was planning on returning. If you had a ticket before, you can certainly produce that.
Well, and I was going to ask you as well, do you have any records that you can show from MPS application showing when the vacation date was starting and ending?
I don't have anything with me. I could go back to the office. There would have been a vacation slip for Dr. Garcia Joven that he would have submitted, so I should be able to produce it. But this is very last minute, and I can do that.
And you said you could get us more information about from Dr. Garcia Joven about.
I have a document that says that he tested for positive for COVID. That's what I have.
Okay,
Are you asking for that document?
I am, but I think Attorney Reardon mentioned a good point. Would you be able to talk to Dr. Garcia Joven and show some proof as to when he was planning on returning?
We're not doing anything like that. Dr. Garcia Joven is ill, and if they want to cross-examine him, they can have that opportunity, but he is not available to testify here.
And you're refusing to get that information from him?
I have not in communication with him, and I have not asked him for his travel plans, no.
Can you do that?
Can I do that?
Yes. If I tell you to do that, if I tell you that we'll take a break, even if it means adjourning, coming back tomorrow, if
Okay.
it's going to take parties that long to get the information, if I get something from you showing what you have on your records from MPS about the dates that Dr. Garcia Joven had requested vacation, and then something from you, the COVID test, as well as something showing his flight plans, I'll make a determination then whether we should continue the hearing until some time that Dr. Garcia Joven is available to testify, and then the respondent can put their witnesses on.
Okay. All right, are we done then?
I think so.
All right.
Produce that by this afternoon, if you want to continue on this afternoon.
I think you said you won't have that information from.
I have no idea if or when I'll get that information. As far as I understand, he is sick with COVID.
Right.
Right. So, we'll see what happens.
Okay.
Are we done?
I think we're done.
All right, great. Thank you very much.
So then tomorrow, I'm assuming there's no hearing?
We'll see what happens.
Well, I want to know.
Well,
And I want the other report.
I'm not able to tell you something that I don't know.
When will you let us know?
When I have that information.
Okay, I need to know by the end of the day today, because I'm not going to show up tomorrow and go through this again.
Okay. What does that mean? What do you need to know by the end of the day today?
First of all, if he's able to testify tomorrow, we can do it virtually.
Okay.
Secondly, I want to get the information from him as to his COVID test as well as his plate plans. Because I need to know, I can't keep continuing this hearing without knowing if he had any intention of appearing.
No, what you're doing is discovering bad faith on behalf of the employer. That's what you're doing, Judge, and you know that's what you're doing.
Actually, I'm not. I'm trying to give you an opportunity to present evidence.
We don't need to they have not put on anything that would substantiate bad faith. So instead, in absence of that, you're now fishing for bad faith.
I'm not fishing for anything.
I think we all know that that's incorrect, Judge. We're on the record here, the tape is going.
We're not on the record.
Can you go back on the record, please? Because I need to get this on the
told me
record.
we're off then.
Yeah, I'm sorry.
That's totally okay, but.
We might be here for a little bit.
Can you let me know where we ended? Like, what was the last thing that was said on the record? Thank
You said you don't have that information. I can only get everyone on that information as far as I understand is COVID, right? So we'll see what happens. Are we done? Yes, great. Thank you very much.
All right, so I just want to be clear, I would like by the end of the day today, the information from you about Dr. Garcia Joven's plate plans as well as his COVID diagnosis.
Right, and I want to make clear that as is a long standard pattern in all of these cases with MPS and yourself, that there is now more evidence of bias. And what we have here is a blatant attempt to not have this hearing just like we did for Dr. Keither. What we've got here is bias by this tribunal here that frankly is doing the work once again of the employer, MPS here, and is not acting as a neutral tribunal by any stretch of the imagination. That's what happened when you were selected for this case at the beginning, when the media case for Dr. Keither, the email that went around, when Judge Alice DeLeo conferred with Matt White about staying this case, Dr. Keither's case. This also happened when you made several, this is you, Judge Brown, that we're talking about, made several rulings specifically on Dr. Garcia Joven's case that limited discovery, that limited the ability of Dr. Keither to organize and work with Dr. Garcia, that limited Dr. Garcia's ability to work with Dr. Keither, that limited Dr. Garcia's ability to work with Dr. Ford, that limited Dr. Ford's ability to work with Dr. Keither, that limited Dr. Keither's ability to work with Teresa Falderon and other MPS complainants. That was done, the tribunal gave them a 30-day stay without any action on their part, without any basis, without there being an ALJ in there. There was an ALJ, it just turned out it was a secret ALJ, Alice DeLau. That is going to be a continuing theme here and what we're going to discuss here because as we know, Judge, you have been secretly just conferring on this case with Alice DeLau and that she has been participating in making decisions on this case with yourself. You have not acknowledged that fact, but we have been able to show that through public records. It is quite clear here that we're not getting actually, this is also true, that Maria Salsor has been part of this continue of prejudice against the employees who are seeking redress from MPS. Now I know that the ERD looked bad because of the 30-day stay in the media email. I know the ERD didn't like having Dr. Garcia Joven's case in the media. I know that you particularly didn't like having your name in the media, or for example, when I put out an email to WELA, how then you responded within hours on these related cases. You didn't respond for months before that, but the moment I put something out on WELA mentioning how the mediation style and how these things happen, then of course there's an adverse decision with, again, no basis. That was similar to when we asked you to recuse yourself. There was just no basis. Well, if we're going to have a tribunal that can't follow any kind of law, that just makes things up as they go along and secretly acting behind the scenes. And let's also be clear, because we got to get this one out there too. Why is it that Dr. Garcia Joven's second ERD claim is been unable to progress get a determination for now 14 months? I wonder why that is. We have asked that investigator now for a year. She has told us, I think 8 times, that we would have it somewhere between a week or 10 days. That hasn't happened. We've called her up and said, can we get public records? Would that identify why we're not getting this case? We've talked to Matt White, who said we'll have it within the end of the week. We've talked to Jesus Villa, who said we'd have it. We've had to reach out to him on social media, my client did, to get why can't it get consolidated? Why is it that seemingly any other case that's assigned to this investigator can get a determination, but not Dr. Garcia Joven's determinations? Why is that? I think we're all pretty clear on what the answer is here, and because apparently it's common sense that those two things can't be connected, aren't we? And that, I think, is just another line through here on more prejudice, more unfairness, more, again, handmaiden of the ERD for MPS. It is becoming increasingly clear that the ERD is not fit for the purpose of handling discrimination cases against Milwaukee Public Schools, and that another forum needs to be dealt with here. Again, I refer back to this is Stephanie Brown's letter accusing this says it almost all, confidentiality. That for somehow Dr. Ford and Dr. Garcia Joven can't talk to each other about each other's cases. Because as we know, even though we've had so many attempts here by MPS and the tribunal to keep this information from us, Matt Chasen testified just 3 days ago and was very clear that there's an absolute through line through Garcia Joven, through Dr. Keither, through Dr. Ford. And that through line is Dr. Holliday. And it's very clear that not only did you know that, going back to when we had the first pre-hearing, and then out of nowhere, did this tribunal decide that we couldn't discover anything about Dr. Holliday. So we had to have farce after farce after farce of depositions, where first we had Yashika Spears. Now, Mr. Reardon rage quit from that one. You took no action, of course. And closed that down. Just yanked the court out. Why? Because we were asking questions that he thought. We discovered the fact that he had told the witness that any discussions of anything that happened before 300 days, she was not to answer. We brought that to your attention, you did nothing. Right? So we didn't, and when we found that out, what happened? Then he rage quit and closed off the deposition. We have still yet to have a chance to depose her. You did nothing. Then we go and try in this farce of Matt Chasen. It probably took us 5 months to get Matt Chasen to be deposed in this case or in any other case. Because they kept claiming third-party witness, they kept claiming that they represented him, they kept claiming, again, 10 months. And Dr. Garcia Joven's fees are being racked up, you know this. They're paying for all of this, and yet they're just goofing around, pretending like they don't know what the law is. Now, you ordered back in December that they produce Matt Chasen's documents. What did they produce? They produced some documents and then they blacked out things because they said they weren't relevant. Now, despite the fact that you already was clear on what relevant was and what it isn't, and despite the fact that they know what a protective order was, you did nothing. You did nothing. You pretended like you didn't have an argument, you ignored our argument, and then you pretended like that put no obligation on you to either do any analysis on what they did. So you didn't. You just sat there and you said, well, you didn't respond in time, so hey, I get to make up whatever decision, they win 100%. Judge, the definition of judge is to apply the law to facts. If you just automatically rule in MPS's favor, that's not even meeting the minimum definition of what it is to be a judge. That's problematic, and it shows bias. We also, again, the timing of all of these decisions. Let's go back to July 15th. What happened then? Well, Dr. Keither attempted to view Dr. Garcia Joven's pre-hearing. So instead of having members of the public at the pre-hearing, you canceled it. And the paper trail is there. We laid it all out in detail for you for over 5 pages, and how did you respond? You didn't. That doesn't meet the minimum definition of judge either. When you are confronted with facts that don't agree with your preconceived notions, it's not enough to simply ignore them. They have to be addressed, and they have to be dealt with. When you don't do that, there's no evidence of sifting or winnowing. We brought that to your attention as well. You didn't respond on that issue. Once again, the only analysis I think that we've had in this case so far is whether or not Dr. Holliday is relevant. The legal justification for that is that it's common sense. The second decision that we've had in this case is that for some reason, because Dr. Keither personally assisted in serving Matt Chasen, that she is not allowed to go to a deposition involving Matt Chasen. That didn't make any sense either. But nevertheless, the decision there was, hey, and let's be clear how the progression of that went, because I think it shows here what's going on. The first decision was that nobody can go to anybody outside. I can't have any assistant to a discovery issue involving MPS. But really that meant Dr. Keither, and we all knew it. And when you got called out on it to the secretary, then you justified why it meant Dr. Keither, and only then. And see, that's what shows, and of course there's a lot of discourse between you and Alice DeLau between all of that, but that there is what shows that had you been clear from the beginning that your purpose was to exclude Dr. Keither, then you could have at least underpinned that with some kind of reasoning. The fact that you didn't underpin it with any reasoning whatsoever until after you were called out on it, not just first, but then ultimately to the secretary, and wrote it to the secretary to defend yourself and justified it that way, that makes it clear to me that nobody identified Dr. Keither except for you. So it went from nobody can assist me to only Dr. Keither. And again, the reasoning was nothing other than she assisted something that everybody has a right to do, which is to go serve somebody. Which is so parallel to this situation that I'll underscore it here. Again, there was no basis in fact to do what you did. But so you came to this predetermined conclusion, and then you went to the aid of Milwaukee Public Schools and said, no, Dr. Keither can't come without any evidence. The same thing with Dr. Holliday cannot be, is not relevant to this case. You did so without any evidence. Now you're demanding that my client, who we've represented to you, is ill, and you're putting a deadline on me because I guess you've been inconvenienced here. But again, my client is the one who is suffering from COVID. And we're now supposed to go and produce documents to you for their benefit.
It's for my benefit.
No, it's for their benefit. Nobody has ever they have made an accusation. They have not backed it up with any evidence. You're then going to get evidence here to back up your preconceived conclusion, which is once again evidence of bias. And this line is through all these points, meaning there is no curve, it's the same behavior. And that's why we're calling it out. We're calling it out for July 15th. We're calling it out for the 30-day stay. We're calling it out for the fact that you have been assigned to all of these cases. We're calling it out for the fact that we can't get an ID on the second case no matter what. And that's clearly not happening by accident, we all know it. We're calling it out for what happened against Dr. Keither. We're calling it out for your obvious termination of a hearing, denial of our opportunity to be heard, so that you could not have to be confronted with Dr. Keither. So that she, for some reason, and again, you stated this and you put it in writing, you do not want employees working together. You stated that. You fear that that's a violation of the Supreme Court rules. You also put in there that it's a violation of Supreme Court rules that I represented Dr. Ford and Dr. Garcia Joven at the same time. You're the one who put that word adverse in there. And of course, they picked up on it, and so did an independent body. Now, again, they were able to clearly see what the law was. Again, we're not talking about insurance law. We're not talking about maritime law. We're talking about the Wisconsin Fair Employment Act, which is your job to enforce. And yet an independent body took some minutes to determine what the actual law was. And once again, that Dr. Garcia Joven, employees cannot be adverse to each other in the ERD. And you know that. And you knew that when we told it to you the first time. You knew it when we asked you to recuse yourself for bias. You knew that. You still know it now. And if you don't know it, it's a bigger problem. Because you are supposed to be the one who is judging whether or not the employers have violated the Wisconsin Fair Employment Act. But instead of possibly investigating those LERT decisions there, you published a letter stating that I was acting unethical because I represented both Dr. Garcia Joven and Dr. Garcia Ford. You didn't know whether or not, you said it might be. And you were also very clear that you had a problem with confidentiality, meaning two employees working together to try to benefit themselves and to try to work on against discrimination here in Wisconsin, something that the ERD is empowered and mandated to do. Mandated. Now, we're not asking, I guess what we're asking is fairness. We're asking for an unbiased decision maker. We're asking for someone who doesn't go out of their way to try to punish or get the employee. We're asking for somebody who is not acting on behalf, trying to exclude Dr. Holliday, on the basis, again, of common sense. Yeah, we have that quote, Judge. We've got it. It's in the transcript. You said that Dr. Holliday was being excluded because it was common sense. That's not a law. There is no such thing as the law of common sense. There is a Wisconsin Rules of Evidence that we have. That trumps common sense. But putting the Wisconsin Rules of Evidence in front of you didn't seem to matter, because it seems like excluding Dr. Holliday was a primary concern. That the law was a secondary afterthought, that's why it couldn't be cited to. The same thing, the justification for excluding Dr. Keither was an afterthought. And you know, Dr. Keither is suffering here, and I want to be clear on that. So are all of these employees. They're paying. They're not being paid to be here like Adria. They're not being paid to be here like these two gentlemen. They're paying with their blood, literally, Judge. Now, I know you all know that because I hear Judge DeLao tell employees that when she's pressuring them to settle their cases prior to here. She goes over how difficult it is to prevail, how seldom that, we've got the emails here from you all talking to each other about how great it is when somebody finally prevails in front of the ERD because it happens so rarely. We've got those. Just like we have the response from the Equal Rights Division saying that they will not give us emails between you and Judge DeLao regarding this case because they are deliberations. Now, I don't know what judge I'll put it another way. I know exactly what judge we thought we drew in this case. And draw, by the way, is a misnomer here because it's nothing like a random selection here in the Equal Rights Division, which we know. It is a policy choice that to make you the judge in this case. It's a policy choice to make you the judge in Dr. Keither's case. It's a policy choice that Judge Benitez Morgan is now going to be the judge for the Ford case. That's a policy choice. And we all know that that was discussed. Because again, it's not happening randomly. These things are happening on purpose. And we've got the evidence to show that. Now the problem with all that is that the evidence doesn't seem to matter, because just like when we put the law in front of you regarding what's that Dr. Ford and Dr. Garcia Joven cannot be inverse, that did nothing. You know what you did? You said, I'm not taking the letter out because I don't see anything wrong with it. That's what you said. I'm not taking the letter out, there's nothing wrong with it. Well, the independent body thought there was something wrong with it. They sure did. And again, for them to come to that conclusion only means one thing. That either you know that they can't be adverse and you wrote that, or you don't know. Either way, it's the same problem. And you know it. And we know it. And so when we put all of this information, and I think it was 20 pages, 30 pages,
Yes.
I think we spent a month, instead of deposing Bob Peterson, instead of deposing Superintendent Posley, which you know about. You knew about all of those witnesses left to go. You saw our matrix. You knew that they had delayed. You knew that they had refused time and time again. We sent them notices. They just pretended like they didn't get them. They said we didn't fax them. On and on and on we went. So instead of doing that discovery, we responded to the fact that you were biased in this case. And we spent a month on it. Again, while being peppered with, I think, frivolous motions from them, aided by you. For example, their motion to have me excluded from the case based on your letter. Right? And so again, the reason that's frivolous is because they, being attorneys, and signed their name to a document saying that it was unethical for me to represent Dr. Garcia Joven and Dr. Ford at the same time. Well, they had a duty to look it up. They didn't do that. You didn't review the issue. You didn't at all. You just said the ERD is not going to respond to an accusation of misconduct. Which is what you did. That's how you got out of our issues as well. Whenever we raised their misconduct, you just said we're not going to deal with it. Okay, well, then Dr. Keither gets assaulted. Then he goes up and calls her a coward in my office. Nola Hitchcock Cross had to get up there and remonstrate with these fellows. She had to stop what she was doing in her day, listen to this woman, and how he called her a coward. She had to stop what she was doing, go up there, and remind him about how he had already done this once before. How he had already contacted one of my clients, Dr. Ford, and said about 3 different stories about what it is and why he was contacting her. We put those all in front of you, and you declined to do anything about it. So we did it again. You had the authority then, but you declined. So we did it again. And that's a pattern here that not only is there one set of treatment for MPS and another set of treatment for the employees, but also when there's no corrective action of any kind taken with their flagrant abuse of the process, then they only do it again and they do it more. And we warned you back then, we warned you now, and it's still, what do we have? You need to stop what you're doing. You have to, by the end of the day, have to go find out what your client's ill. No problem, I don't care. He might be dying, that's totally irrelevant to me. By the end of the day, I want you to tell me what his travel plans were. Because they made an accusation saying that